Welcome back. It's Philip Bickle at Legal Tyranny. Today is July 31st, 2020, and we are continuing on the second part of the Kenneth Dine story out of Los Angeles. Let's read this again. So he waited all day until his case was heard, he said, late in the afternoon. A judge dismissed the warrant and told Dine to pay the $10. They issued a warrant. I mean, think about that. Like, any cop that's enforcing this is probably earning a minimum of $20 an hour, probably more. So, I mean, think about the cost-benefit ratio here of trying to enforce what they're doing. It's just silly. It's a waste of money and people's time. Okay, by then, however, the clerks had closed the cash register. Dine had to return to Lancaster the next morning to pay the $10. He then sued in Van Nuys small claims court. The court nearest his home on September 20, 1994. Commissioner Kirkland Nibbe ruled in his favor. Jan Kaler, the Antelope Valley court administrator, faxed Nibbe a letter October 5th asking for an explanation of the ruling. Keller said the court clerks believed that Dine's case had been handled properly. She said that Dine had plenty of chances to pay the $10 by mail. But Nibbe wrote to Keller that the 1985 addition to the Vehicle Code plainly bars the warrant that her clerks issued for Dine's arrest. A reasonable expense to clear up the mistakenly issued warrant, he said, was $200. Presiding Judge Seelick in the Antelope Municipal Court no longer issue warrants such as the one Dine got. Now, this is a presiding judge. Judges actually are above. Let's see, where is he listed? It was a court commissioner that made this ruling. But, again, reading code really isn't that difficult, but if you have reading trouble or anything like that, some of it is going to be a little difficult. But the longer you're in it, the longer you immerse yourself in reading and thinking about these things, just stick with the books. Don't look for other people's interpretations. If you want to check out their interpretations, do it after you've studied it well enough yourself and you feel like you have your own interpretation. And then when somebody else is giving an interpretation, see if that jives with what you think. And if it doesn't, maybe that person's throwing out red herrings. Or maybe you didn't consider certain things that they've mentioned yet. But you want to make sure that whatever you're considering is something that has sources, evidence. Like, any state that you guys are in will have a section of statutory code called the Rules of Evidence. And that section right there is not very long, but just read on what it takes to get evidence entered into the court record. So if you have something and you present it before the court and you testify about certain things, they can potentially enter something into evidence, that's called, and you want to understand what a court would deem as evidence, because it is kind of a slightly, generally it's a higher standard to make sure you're not dealing with hearsay or people making things up. But, if the justice system worked as it's supposed to, you wouldn't see certain abuses going on. But the rules of court, those are things that if they fail to follow certain things, you can potentially use that as an error that's appealed. So knowing how the rules of court or rules of evidence work is important. Plus, you want to keep out as much of the evidence that the prosecutor is going to try to enter as possible. Like, they'll try to enter stuff that they have no business trying to enter as evidence. Let me finish this and we'll get into that. So the presiding judge, now this person deferred to the points made by this commissioner, and that's good. They should have. In fact, they shouldn't have been doing what they were doing. They didn't give Dine the time of day is what happened with the Selig. They didn't bother with looking at the statutory code and the issues that he was raising. Because if they did, if this judge did, they wouldn't have made themselves look like a fool. Okay, presiding judge Selig said the Antelope Municipal Court no longer issues warrants such as the one Dine got. Dine says he will remain vigilant. Most people assume the courts know what they're doing. My personal experience has shown that they don't. They definitely don't. Many of the people on them don't. A lot of the lawyers know stuff that they shouldn't be doing. They still do it. But then I think that there's a certain percentage that they actually don't know certain things. And they sure as hell don't want to listen to somebody that goes in there pro se or say pro per, whatever you want to call yourself, handling your own affairs. They really don't like listening to us. And especially if you go in there super confident. You know, I know this. So they really don't like people that are very confident going in there and saying, hey, look, this is what it says. You guys are doing this. You know, whenever you present your own matters in a court, don't be standoffish. Don't be obtuse or difficult. Try to come across as neutral as possible. And, you know, if you can do that, then you're actually keeping your emotions in check. When you're in court, you don't want your emotions, whether they're positive or negative, coming out. So, you know, if you're happy over a ruling or something, that's great. Save it for the very end. Don't get too excited at, you know, over something in a proceeding starting to go your way, because they'll just turn right around and flip it upside down on your head. And, you know, obviously if you have negative emotions, you know, you get hostile or whatever with the people you're interacting with, then it's like in poker. You've lost your cool. And you're not likely to continue making logical arguments. You are going to start interjecting emotional content into what's going on, and that's where they can get you off the track of the things that you want to stay on. It's very easy to get people sidetracked when they're emotional, because, you know, you just lost your anchoring point, the logical arguments, the points that you're trying to put forward. If you stay neutral, keep your emotions neutral, you're going to have the best shot of getting through while doing the best performance that you can, because most of you are also going to be anxious. The average person's going to have anxiety. You may have some adrenaline going. Trying to be neutral with your emotions will help keep that in check to some degree. And you should, again, be able to stay on your path, stay on your points better. And if they try to get you off those points, you'll be able to catch them when they do it. And, you know, they might start to bring up some other topic or whatever. And you know, then, like a lot of times what a judge will do is talk too long. They'll just give you like a couple paragraphs. And that's essentially like a cognitive attention breaker, because they're putting out a new topic and they're going into detail on that topic. But if you catch them on that, try, you know, maybe even jot down on your notes what it is you're discussing, or put a star next to what you were discussing. And then when they pause or they break for you to not when they pause, but when they're done saying whatever they're going to say, that's when you say, okay, I appreciate you bringing up such and such, but this point needs to be addressed before I move on, because I put a lot of time and research into this particular issue and it needs to be addressed. And I'd like to come back to whatever it is, you know, they just brought up after we've finished with this particular point. And whatever the points are that you're raising should be points, you know, a lot of the stuff that I've brought up in my videos, if you study it procedure, anything that they're not doing and you're nailing them on, don't ever drop that. Don't drop it if you can help it. Just keep going back to it. And if a judge says, oh, it's my ruling that such and such on this issue you brought up, that's the point where you're going to drop it. You say, okay, well, you know, I've made my point for the record on appeal, and you go on to your next point. Or if there's something important that they brought up in a previous, couple paragraphs that they said, go back and address that. But a lot of times they don't bring up stuff that's critical to the case or things that you could even appeal. Like they're non-issues kind of, but they're tangents to get you off of what you were doing. Okay, let's see. Most people, let's see, assume, blah, blah, blah. Okay, so that's it. Yeah, that's it for this section. I tried to put my own points in there and my own experience as best as I could. I know some of it may be a little bit scattered. Again, the mold toxicity is just completely messed up my attention span. But if you guys want to find this particular case, I would try doing a search on this section right here on Google, and I think you might be able to get it. Otherwise, right here, okay, so right here is the URL. If you want to pause it, and you could type that in and get it. And then if you find this information interesting or useful for your research on this set of issues, make a point to save this actual web page. Let's see, what do you do? You would go down to save page as, and then you would do something along the lines of like, just boom, right there. You could do the complete one first, just to make sure you got it, and then do the HTML only. Then try to open the HTML only first when you're disconnected from the internet. And if you can see all the text, if you can see all the stuff you need, then just keep that one, because the complete web page can be significantly larger in size. So that's how I tend to document my stuff. But let me see, what other points do I have on this? Well, I mean, look at the situation. This guy had a $10 fee, and they issued a warrant over it. They issued a warrant for somebody that did not commit any sort of violent crime, and they issued a warrant for him because he didn't show up for some sort of court-related matter tied to failing to show up the first time. So this business of setting up warrants like that for failures to appear, especially having a computer just spit them out if it's entered that they failed to appear, it's not lawful. It has to go through the prosecutor first, obviously. So it's a pretty tiny and simple set of issues I raise here with their failure to follow process in traffic courts. And I don't know, I'm just going to keep repeating this stuff because there aren't a lot of people discussing this set of issues. And you got guys like Mark Stevens, who I have no problem saying it's my absolute opinion, which I think is 100% correct. He's a subversive. This is the problem with a lot of these people. Like, they understand that you have to feed people a lot of truth and couple that with omissions of truth or actual outright lies to fool people. The stuff that he's doing, there are some people that have definitely had results, but Mark Stevens didn't come up with this stuff. The stuff that he's doing is similar to what I'm doing. He came across the work of other people that already found these issues, and he's just stuck with a couple issues there. Like, he hasn't branched out to these other things. I mean, if you think about what he recommends, trying to tackle the jurisdiction issues, they want you to ask the court to provide, or even ask the prosecutor to provide evidence of jurisdiction. Like, just go in and tell them they haven't submitted this, that, or the other thing. There are certain things that are well established in case law, particularly the charge, And if they don't follow the requirements for filing a charge, then they obviously don't have jurisdiction. Call them out on that. When you go in and you start citing some of the things and the wording that he's used, these judges have what are called judges' bench books, and they actually have catchphrases in there. So if you start using certain things, they'll think you're tied in with something like, say, this quote unquote sovereign citizen group. I should do a video on that judge's bench book that shows that. Now, I kind of use a little bit of that to my advantage on occasion in strategy just to make them careless. So, I can't remember which catchphrases. I've used a few catchphrases that I know that was in the one judge's bench book manual that I had. And I was like, let them see this at the very beginning so they tune out the rest, which they typically do. They don't read what they're actually required to read. When you give them a motion, they're required to be familiar with that before they roll on it. They need to read it. But if you put a few catch words in there, they may be like, oh, this is a sovereign citizen. And then they just, gloss over the rest. So you may be in sometimes for a longer fight like that, but you make them look terrible because then they just rolled against something, and every issue that you brought up in there, if you're bringing up the issues that I'm pointing out here on failure to do certain things in procedure, if you're nailing those things, they look terrible if and when it goes to an appeals court or later down the road. You could be like, well, you rolled against this, but they still haven't charged me, so if you can make them look bad, it embarrasses them. They're humans. Let them get embarrassed. There's so much corruption going on. If you got to fight it well. Use, the best techniques that which does include psychology, and I do have that under my belt, but you guys can pick a lot of that stuff up too. Persuasion and conditioning, stuff like that, and you can apply that when you go in, but it's a lot to juggle. The main thing is to get your points down, put them into a motion, have it written, have that filed, and then your butt's covered. So when you go in, if you get distracted or anything else happens, whatever you didn't do orally, it's already written. Your butt's covered. So I think that's another problem with some of these other people that tie in with Stevens. I don't think they lean heavy for like making written filings, which is just ridiculous because that's the absolute best way to make an undisturbed argument. You prep everything at home or wherever, do your research, you get it all down, you don't have anybody interrupting you, you don't have, prosecutor and judge playing tag team, trying to misdirect you and go off on tangents. You'll have that in, and that's there for the appeal. So even if it's not in orally, that motion will go up with an appeal. Okay, we're going to wrap it up here. If you found the information informative and useful, please give the video a thumbs up. If you're not subscribed, please consider subscribing. And if you are subscribed, please hit the notification bell so you know when I have a new video posted. And as always, if you can copy and paste videos that specifically would help certain people, that helps me out because this information isn't going to get out any other way. Thanks. Until next time.